morning, everyone. So we are glad to have Dr. Vedashi here with us today, who has kindly agreed to have a discussion with us on the topic of dissecting the status and role of property laws in India. Thank you so much, ma'am, for accepting this, and thank you so much for gracing us with your knowledge today. So, before we move forward, could you just explain us what is property law and what all is covered under it?
Property law as a generic term includes many things in it. So simply classifying, we understand it as a movable property, intellectual property, and there are some rights which are attached to the property, inseparable, do not have an individual identity, like easements, licenses provided, and property on succession, inheritance, all these which are actually basically having the nature of both movable, immovable, tangible, intangible, which has a persuasive commercial value, gets into the paradigm of property. So this is generally understood to be property.
So, does the law define what a property is for a person?
Yeah, for a person, yes, all kinds of properties are attached or understood for a person. And here, when we say the term person, we need to distinguish between legal persons and what is a person accordingly. So, when you say legal persons, it includes human beings, we are natural persons, and artificial persons like company, society, club, which has a status of being sued and to sue also, enforcing the liability in the society. So that means here, when we say a person has a right, yes, he has all the rights which are attached to the property, irrespective of whatever be the kind of property, but that has correlation to what he owns and what he disposes. There are two things, what he owns and what he disposes. So based on this, a property is always connected with the person.
Thank you, ma'am. So why is it that people take their property dispute so seriously? Like it is a dispute at the end of it, but they take it very personally also, right?
True.
Why so?
History is an evidence. We see legacy of cases which are fought for so many years. Firstly is the economic value of the property, and second is the human ego. Why should I allow him to have my part of property, or why should I let him win over this? It might be even for 1 feet by 20 feet, but the fight is a long run. It definitely takes a turn like ego fight among the contesting parties. It is seen, it is true, and it is very well established also. Perhaps should not be, but then hard fact is it is true.
It is there, it is.
It is there.
And the courts have repeatedly said that property disputes have put a very big burden on them. And
on the courts, you mean to say?
Yes, ma'am.
Yes.
So how long does it take to resolve a property dispute, and why is it such that they have been, being such a burden on the courts itself?
See, first and foremost, if we look at the burdening of the cases on the courts, there are two dimensions to understand. First is the intention of the parties who go to file a case in the court and get into contesting of these cases. Next is the administrative part of the property law concern. For example, the government departments who are holding the records, or some registration lacuna, some double registrations, multiple registration of the same property, and sometimes the survey numbers are repeated for the same numbers are repeated for more than identification of the property is not something which you do, which is done by the administrative authorities. So we see a lot of lacunas even in the maintenance of the records of the property, which actually sometimes gives rise to a lot of litigations in the courts. Second is, yes, overlapping situations. Like I can give you one example. Like there was a provision for the power of attorney holders to sell the property, alienate the property. But which the actual owner of the property also sold the properties, power of attorney holder also sold the same property. So what happened eventually is that there are multiple buyers and multiple sellers to the same property. Now there becomes a question of title, which is becoming a dispute in the court of law. Then there was a good amendment which was brought in the property law that power of attorney holders cannot register the property. An absolute sale deed cannot be registered by them. That needs the owner of the property to comment, wherein they are entitled to enter into an agreement to sell, but a power of attorney holder cannot alienate the property through an absolute sale deed. Till then, you can see, where in High Court of Karnataka only you can see how many appellate cases which have gone from the civil courts and even in the civil courts, a lot of pending cases prevailed. And after this amendment, that has been cut down. So I think the revenue departments and the registration rules and some basic rules which are very basic to the transfer of property needs little more wiserness, to be very frankly, to be more understanding that there shall be no disputes and work in coordination. Then I think we can reduce the number of litigations.
Ma'am, so Supreme Court recently, about a month back, gave a judgment where they said that the title is not the absolute ownership. So do you think that is there to adjust with the corruption that has been going on with the real estate department?
See, how do you ascertain a title in a property? A deed.
Okay.
And where do you get the deed from?
The government?
No, it is the parties who enter into got registered. And registration department, or we can say sub-register offices, do not get into the business of even identifying whether that property prevails or not. You go and want to register something, they will apply Registration Act and they will register the property. Identifying whether the property is without any disputes or it is prevailing or not, that process is not adopted at all in the sub-register office, basically, because the power is not there for them and they are not supposed to do it and they don't. So what happens, even if you are the owner of the property, not owner of the property, or you have the somewhere you have a small right to use the property, they could have gone and transferred the property to many people. That has happened.
Okay.
So this is the reason why we have multiple disputes in the titles of the property. And one more thing is title is very important in a property, plus the possession. A title without the possession does not give a complete absolute right over the property. This is something we need to understand coherently. Title and possession go hand in hand. Possession itself does not give you the title. Like adverse possession is anyway not valid in India, likewise. And only the title also, when you don't have the reach out to go and have the possession of the property, your title becomes a mere title in the papers. Do not have the possession, so then you will not be considered as an absolute owner of the property. For an absolute ownership, we say that title and possession go together. So when Supreme Court has taken this stand, it is very well understood that only titles without possession does not become an absolute title to the person, whoever wants to claim it. So that means there are some specific relief factors there, where we have recovery of immovable property, possession of immovable as one of the specific relief. If you can enforce and get back the possession, then your property becomes, your right in the property will be understood as an absolute right in the property. Otherwise, it will still be a title in the paper. So possession is very important and title is also equally important. It is like two coins of the two sides of both same coin. One cannot work without the other. Neither possession itself will create a title nor the title itself will give possession. It has to go coherently with each other. So that means when you say I am the absolute owner of the property, your title should be free and also possession should be absolute. Then only we say that you are the absolute owner of the property. Of course, I teach this when I teach property law, how to understand absolute ownership. Where do you cut the line to understand what is not an absolute right and what is not an absolute right and what is an absolute right in the property. So this edge you need to understand. So Supreme Court has rightly said this, and even in jurisprudence we say title possession is 9 points in law. Unless you have the title, it does not give you an effective ownership over the property. So it is a very clear understanding that Supreme Court has rightly taken the decision saying so.
So considering even you have mentioned that it's a very personal topic for everyone, right? So in the 44th amendment that happened, the government removed Article 19(1)(f), which was basically right to property as a fundamental right, and they moved it to a constitutional right under Article 300A. What is your opinion about that discussion then?
See, the objective behind this amendment is to restore the absolute nature of the property. As I said, absolute ownership. See, when you say right to property as a fundamental right, so we sometimes rent out the property.
Okay.
The tenant gets the rights to possession. But that is also one of the ways of enjoying the property. If you want to have the property vacated, he can go to the court of law telling that this is my right to life, because right to possession of the property, he can say that it is violation of his right to possession and enjoyment of the property. He shall vacate whenever he wants. So there is a clear threat upon the absolute right which the owner has. There is something which which at that time, before this amendment, a lot of rent control departments were there, and all the Rent Control Act was supporting the tenants and not the owners. Owners at some point of time also came to a conclusion, we will not rent the properties.
That was mostly done to have the relationship between tenants and landlords to be more properly managed.
More properly managed, because when you say, as I said, right to property has two folds, possession and ownership. When the owner gives the property on the rent, he is giving the possession. And if the tenant wants, he will continue, and if he will not continue at the instance or the willingness of the owner, but he will enforce it as a fundamental right. So eviction and getting them out of the property was very difficult before. And one more thing was eminent domain, where public interest is given more preference than the individual interest. That is, private property is given lesser emphasis over the public use. So when we say fundamental right, acquiring the land for public purpose and for developmental purpose, all that becomes more difficult. And approach is that it is an absolute right. See, fundamental rights are absolute rights, but it has a reasonable restrictions, but it has to, the rigidity is more in ensuring the enforceability of fundamental rights.
So is that the main difference between the nature now that the right has changed?
Yes, basically because if a fundamental right is impeached, then so Supreme Court has to protect the fundamental right, right? So then how do you achieve the objective of eminent domain, public cause? So we see so many acquisitions happening for the widening of the road, National Highway Authorities of India. So how can they acquire when it is a fundamental right? So they included it as a constitutional right because there was a need for acquisitions, and that would be very difficult if it is a part 3 of the Constitution.
But let's move back to Magna Carta, which was the first human rights document, and it's heavily studied.
Yes.
That was quite, revolving around the property rights of a person.
Yes.
So now that you are saying that they're trying to remove the rigidity of the protection towards them, isn't that us evolving backwards towards the protection of rights?
See, we are not completely removing it from the scope of the right. We are still retaining it as a constitutional right. Only thing is we have removed it from the fundamental rights. So even when there is impeachment of a constitutional right also, there are legal remedies. High courts and Supreme Courts have the jurisdiction to provide the remedy because it still fits into the ubi jus ibi remedium concept. A right is given to you by the state, property right. It's a constitutional right. And we see that whenever there is violation of this in any form, you can always seek redressal in the courts of law. High Court has a jurisdiction and Supreme Court also has a jurisdiction, correct?
Yes, ma'am.
So we've seen, I've taught you when I teach administrative law, I do teach them this. How property right is violated by the administrative authorities by not following the procedures which are given to them for acquisition. Now that gives rise to a very good question of fact and question of law both, which needs to be answered in the court of law, which really gets addressed in the High Courts and the Supreme Courts respectively to their jurisdiction.
Ma'am, now coming to the main question, what is the approximate income that a property lawyer or person who is litigating into the property law can earn up to, maybe in a month or a year?
See, when we categorically understand junior lawyers and mid-level lawyers and little high-profile senior advocates, it depends upon their this aspect also, what they are actually. And raising it minimum, as far as my understanding goes, it is raising from 15,000 from the junior advocates. And when we say mid-level lawyers, we can say that they have experience from between 5 to 10 years. So they might earn around 1 to 1.5 lakh, something like that. 1.5 lakhs,
A
something.
month?
Not on a month, but hearing basis.
Okay.
I tell you, this is the, let me tell you, and the senior advocates, they can more than go up to 5 lakhs to 50 lakhs, owing to the nature of the litigation, nature of the property, the situation, where the property is situated, to be very precise, the market value of the property, and what is the type of the litigation. So is it just dragging case? May not, they know that they're not going to win the case. It is, they're dragging it. So in that case, the fees will be little negotiated, or getting some specific small orders for time being, just to hold on the time. So it depends upon all these things, but by and large, we can understand that it will range up to 15,000 at the lower level to the 50 lakhs at the higher understanding. For example, when you take real estates, big developers, the dispute and the cost and the dynamics are completely different. So it will vary. So that is a, but if you go on numericals, you can go from 15 to 50 lakhs, 15,000 to 50
So
lakhs.
this organized real estate sector that is there, the Prestige Brigade and these big companies that are there, they would probably have their lawyers, right? They would be able to earn a little bit more compared to the litigating people.
See, that goes on the corporate advocates, corporate style,
Okay.
because they will, all these developers hire corporate advocates. They will get attached to a corporate lawyers.
Okay.
So they do all those things, and in corporate, it's always 1 to 5.
Yes, ma'am.
So this is the understanding. So they always they earn higher 1 to 5. Corporate is always like that.
Yes, ma'am.
Solicitor firms, corporate firms, they're on a higher side and they earn accordingly. And when you look at the stakes are also high. Because when you look, for example, if there are violation of bylaws, so the advocates will be handling it in a different way. What is the degree of variation in the bylaws? How much they have not complied? So based upon that violations, they will try to reduce the fine and other things. So they will be paid more by the corporate, the developers. It depends. It has a lot of dynamics in that.
That would depend on the nature of the litigation.
Nature of the litigation, stakes involved, and nature of the property, value of the property, and lot of things come in there. But numerically, 15 to a junior lawyer can earn, up to 550 lakhs a senior advocate can. I'm just telling you on the higher and the lower end of the scale in the earning side in the property matters. This is one of the evergreen matter, actually speaking. This and administrative law are evergreen, because there are always problems, there are always disputes, and it is always an earning field. So we can say now blooming is family courts. So they are also in that line, but this is always evergreen. Property law is always evergreen.
Ma'am,
Yeah.
so now like we previously discussed where, the courts have a burden because of property law disputes. Now, India has a very good culture of arbitration that has been picked up. Many Supreme Court judges have been, emphasizing that people should try to focus on arbitration so that they can resolve matters easier. So do you think, considering the nature that this property law dispute has, can we move towards an arbitration sector focused dispute resolution for property law matters?
Yes, I think we should look little more progressively in this matter, where involving the arbitration method as a pre-trial method would be more beneficial. So when I say pre-trial, of course, plaint is filed, written statements is accepted in the courts, and then before the commencement of the trial, it is always better that arbitration happens, An arbitrator will be a neutral person. Neutrality is the basics of arbitration, who will be inviting both, having talk with them, try to negotiate, try to make them aware legally. And as I said before also, parties or the owners of the property know the discrepancies in the property better than anyone else. Sometimes they will be telling the lawyers also, this is this is it, where lawyers may not be able to grasp it at once. So they know it better. So when the arbitrators sit there and try to bring the reality check, that's what they do, and not in a very harsh way. And they might even open up for many things, even to say no to the litigation or take a strong decision why they are going to litigate, go for the trial. So these things, and moreover, it is when it comes to property matters, it depends on the documentation. If the documentation is fine, then I think the winning is easier. And corroborating the documents to the facts is what happens in the trial. And if arbitrators can give them a glimpse of what could happen, then I think they will understand and prolong the cases, and no one can enjoy the property, because nowadays everybody is asking for status quo, asking for injunctions, but finally it ends up with status quo.
Yes,
Status quo, what happens? If it is an income earning property, then everything should come to the court. Injunction, attachment orders, injunction orders, all those are incidental to many of these things. So that will affect both the enjoyment of the property and income from there, and there are many people who are involved in that property. So all these things, it becomes an introspection method, and arbitrators are one who can adopt any method, but a judge cannot. See, judge has to always go by what is presented in the articulation in the court by the advocates.
Yes, ma'am.
If they prove, yes. If they can't prove, then the judge cannot say without proving the cases in the plaintiff side or the plaintiff side or on the defendant side. The judge cannot do that.
But the problem with arbitration is that if the people are petty and if they don't want to resolve the issue, even with arbitration, the issue won't get resolved, right? Because property disputes are petty at the end of it.
Yeah, that could happen. That is one of the limits. See, this is just a trial. We are just trying. We are not telling that it is going to be conclusive. Like how in family matters, mediation is done. Moment there is a case filed, petition is filed, and the parties asked to attend the court, and they will come up with the written statement and the reply. And before the commencement of this next stage, they will have a mediation. They want, the objective of the family courts is to bring the relationships back, because we don't want to give breaking homes as a sign of our society. Objective is, if there are small things we can resolve, and lot of guidelines will be given, lot of overall talk will be done. Sometimes when the husband or the wife are wrong, they say you people are wrong, or take proper sides, and they can somehow tell them, yes, you are wrong and this is not the way, and make them realize a few things. So that is adopted. Similar terms, if we adopt arbitration, negotiation, here, what are we, end result is this, what could maximum happen in the court? So it is just a time consuming component. So they might think, why are we doing this, and what is the objective? It is just a chance to give them a way to introspect themselves. And if they still want to go on with the litigation, nobody can stop, because Article 14 gives them the right.
Yes, ma'am.
Access to justice is base of our constitution, so we are letting it happen. But we can just have one round of introspection. I think actually this method was followed with the mediation method and all, even in the previous, when our kings were ruling. If Panch, they used to sit and they used to resolve the matters in the village. Gram Panchayat used to work a lot on that, and we have Gram Sabhas, Gaon Sabhas, trying to resolve all these property matters. So I think we as ourselves, as humans, we know things, what is wrong and where it is wrong. So we can try to bring in a parity and try to harmonize the situation, so that we can reduce the number of cases in the court of law. So I think that is the best method. We should train more arbitration components with our advocates, and I think with institutional arbitration we can go pro into this method. Work parallelly with the courts to reduce the burden on the courts, and courts also will have less cases to address, and so that some trivial matters come. So trivial matters can be sorted here only. Okay, if the other person is ready to pay the compensation, so they can just manage it and resolve it like that. So it can happen. If, for example, if the neighboring person has 1 feet by mistake or by intention, he has come inside your property. Yours was a vacant land. So now you say, my land, yes, taken. Now I want him to break the building and give me that land. So instead, then arbitrators can say, yes, what he has done is wrong. But definitely, since you have not yet constructed anything, you can take an equitable rate for that and let not go for breaking the house. So some resolution, we can resolve the problem and try to bring in the harmonization. That can happen over the table, and that is one of the goals of arbitration. So adopting that would be better, much better. So we need to look into these things. So adopting that is really good. Okay, who to adopt it and who to appoint, I think we should have a regulatory framework for that, and a mechanism needs to be created by the state, and then do it, because it has to work with the judiciary. It works with, that's why it is called as alternate dispute resolution system, to work parallelly to the courts, right, and try to reduce the burden and alternate solution. It can be done. So it is more, and institutional arbitration will help more, and making it a strong structure of the country. It is good. If we can do it, is very good.
Thank you so much, ma'am. This was a very enriching session for all of us.
Yes.
I hope to see you again soon. And I hope that our audience will be able to understand everything that we have said, and it will help them also. Thank you so much for your experience here today, ma'am.
Yeah, thank you very much. And my experience with student is like, when I teach property law, I will tell them how court will look at the situation, why court is coming. And so I explain a lot of cases, and I bring them to that understanding that how court looks at this case, why court is having this decision. So that's where the students also, yes, correct, no, but the ground reality, yeah, there's always that component, right? Ground reality and procedure. So this kind of methods will reduce that, and I think we may need more better arbitrators than more number of advocates in the future, so that disputes or the lists can be resolved in a more smoother way. So I want to bring in that in the mind. So when I discuss a case in the class, I emphasize the reasoning, why court said so. What is in the mind of the court when it has said so? What is the difference? Why that line is brought in by them? So I make it a point, because at the end of the day, they can't go to the court every day. So it is our responsibility to bring in that in the court. So I emphasize on cases, explain a lot of cases, ask them to prepare a case and come, give them a case and explain the case, because they let them understand the court's mind. Okay, so that is very important, I feel. Yeah. Thank you very much for giving this opportunity.
Thank you so much, ma'am. Yes. It was wonderful having you here with us today.
Thank you. So we'll have some more sessions like this. Okay. Thank you.